um, the webinar as they're registering. Won't spend too much longer waiting because uh, Hayley's got quite a lot of stuff to run through. We don't want to interfere with that. So my name's Steve Davis. I'm the PPMA Treasurer and Branch Secretary. Um, Welcome everybody to this seminar. It's obviously well attended, Navigating the Employment Rights Act. This has been identified and put on for us by Commercial Services Group, and Hayley Titchener from Legal Connect, who's a senior legal advisor. She'll introduce herself in a second. She's kindly given us the lowdown on the latest with the Employment Rights Act and what we can expect coming up in the next few months. So without further ado, over to you, Hayley. Thank you.
Brilliant. Thanks, Steve. Yeah, so afternoon, everyone. Thanks for joining this. So yeah, just by way of introduction, my name's Hayley. I'm the Senior Legal Advisor at Legal Connect. Legal Connect is our legal division of HR Connect. HR Connect is one of our businesses within Commercial Services Group. So now the Employment Rights Bill has been passed into law, what I want to do is run through with you the changes under the Act which are coming into force, when they're coming in, and how you can or should be preparing for those changes. There's obviously quite a lot to cover today in our session. We've got 45 minutes. If you do have any questions, just pop them in the chat. We might not have time to cover them all, but what I can do is after the session, send around an email to everyone answering the questions that are raised. So before we refresh ourselves with the implementation timeline, I just wanted to touch upon some research which was recently carried out by Commercial Services Group. And this explores how prepared public sector organisations are for the reforms and what support they feel is needed in order to implement them. So thanks, Grace. If you could just move forward to that slide. So this was commissioned in October last year. We had more than 500 senior leaders take part in this research from across local government, health, education, housing and emergency services. And their insights were complemented by findings from a national survey of more than 3,000 employees. So the full report, Managing Change, the Employment Rights Bill and the Future of Work in the Public Sector, can be found on the CSG website. And like I said, we can send the link in that round robin email as well after the webinar. So I've just set out here some key findings from that report, which may well resonate with you. As you can see, ultimately, whilst the results point to cautious optimism, with leaders broadly supporting the aims of the reforms and recognise their potential to improve staff wellbeing, recruitment and retention, there is preparation and implementation of the reforms naturally remaining as a concern. So hopefully this webinar today will go a little way in the time that we have available to alleviate perhaps some of those uncertainties that you might have, and to provide you with some key takeaways. Thanks, Grace. So I've just set out on the next slide here a timeline of the changes. So this mirrors the Employment Rights Bill roadmap, which was published by the government in last July, and that still applies. Appreciate, sorry, the font's a little bit small on the actual slide here, but again, we'll send you the link so that you can have that in a bigger format for afterwards and for use. What I've also set out on the slide is a timeline of the consultations that have already been launched and those that are expected. Now, these consultations are important because they will form the detail for further regulations. And then following these, the government will produce clear and comprehensive guidance to help us navigate the changes. And that will be made available in advance of the changes being implemented, which allows us to prepare and be familiar with that detail. So we have five consultations which have already been published. So they relate to bereavement leave, right of trade unions to access workplaces, the duty to inform workers of their right to join a union, enhanced dismissal protections for pregnant women and new mothers, and e-balloting. And what I will do is have a look at those consultations in a little detail when we discuss each of those areas as we move forward. The other consultations you'll see were due to be published winter last year, early this year. They are still awaited. And so we're sort of watch that space as those consultations hopefully come out relatively soon. Thanks, Grace. So moving on then, let's have a look at the measures that took effect at Royal Assent and will be implemented on the 18th of February. So as you may well be aware, a huge proportion of the Employment Rights Act covers trade unions and collective bargaining. And the Act makes some significant changes to the trade union recognition framework, the process, and the ability of unions to take industrial action. And I think there's some confusion as sort of when all these changes are coming in. So if we look at those sort of three general areas, so changes to industrial action and ballot reform, that's going to come in February. Procedural changes to sort of the framework, that's coming in April. And then enhancement to trade union access rights and employers' duties to inform workers about their union rights, they're coming into force in October. And it's those changes which are probably likely to be of most significance to you. So just touching upon these changes then that occurred when the Act received Royal Assent, so that was the 18th of December. So what we saw is the Strikes and Minimum Service Level Act 2023, which is set out on the slide here, that was repealed immediately on the 18th of December. So that gave the government powers to set minimum service levels during strikes in essential services. So where that's been repealed, those minimum service levels have been removed. What we then have is the Trade Union Act 2006. So that currently imposes various limitations on strikes, including longer notice periods, restrictions on picketing, higher ballot thresholds for certain important public services. Those elements of that act, they are being repealed as of the 18th of February. So as of the 18th of February, the notice period a union must give to an employer of industrial action is going to be reduced from 14 to 10 days. The mandate period for industrial action following a successful ballot is going to increase from 6 to 12 months. And the requirement for unions to appoint a picketing supervisor will also be removed. So those are those provisions under the Trade Union Act, which will be repealed and then replaced with those amendments I've just gone through. So in addition to those changes, you're going to see changes to the political fund rules. So the requirements for unions to ballot their members every 10 years on the maintenance of a political fund will be removed. And instead, unions will have to remind their members every 10 years that they can opt out. And new members joining a trade union are automatically opted into contributing to the union's political fund if it has one. We're also going to see simplifying of industrial action notices and industrial action ballot notices. So unions will no longer have to provide information on the number of employees in each category or workplace, and they won't have to disclose the number of employees expected to take part in industrial action. And that's obviously going to make it harder for employers to plan during those periods. And then finally, the current 12-week limit for claiming unfair dismissal from the start of industrial action is going to be removed. So dismissal for taking part in industrial action will become automatically unfair at any time. So the takeaway for you, whilst those changes are significant, they're not going to impact those day-to-day management of your employees. And there's probably relatively little that you can be doing to prepare for those changes coming into force. Just so you are aware, on the 8th of January, the government published guidance on these changes that are coming in on the 18th of February. They also published a draft revised statutory code on picketing and industrial action ballots. So you can, if you need to look at that detail, you can find them on the government website. Thanks, Grace. If we just move on to the next round of changes. And these are coming into force in April of this year, and they're coming into force on the 6th of April. And these implementations focus on day one entitlements and broader workplace protections. So what we have is paternity leave and unpaid parental leave. So currently employees have to be employed for 26 weeks before they're entitled to paternity leave, and employed for 1 year to be eligible for parental leave. The entitlement to paternity and parental leave will become what we call a day one right. So that length of service will be completely removed. It's also going to be possible to take paternity leave after shared parental leave, which isn't permitted at the moment. And the idea of that is to give individuals more flexibility about how and when to take their leave. Just to touch upon as well, because I think there's a little bit of confusion. What we did have is the Paternity Leave Bereavement Act 2024, which came into force on the 29th of December. And what that did was remove the 26 length of entitlement for paternity leave where a child's mother dies in connection with the birth. So that's already come into place. So that's a day one right. But the paternity leave generally outside of that situation, the day one right will come into force as of the 6th of April. So what you need to be doing is updating your policies, your handbooks, your contracts of employment in readiness for those changes. You'll also need to be aware of a potential increase in leave requests and from those new employees as well, because as we say, it's obviously a day one right. And you'll need to consider the potential impact from that resource and finance perspective. Whistleblowing. So employees who disclose a breach of health and safety obligation currently or another breach of the law, these are called qualifying disclosures. They're protected as whistleblowers if they reasonably believe the disclosure is in the public interest. The disclosure of sexual harassment will be added to the list of what counts as a qualifying disclosure. This isn't really a significant change because currently if someone disclosed sexual harassment, it's likely that it would fall into the qualifying disclosure of breach of the law. But this is being set out as a separate qualifying disclosure. So what you'll just need to do is update your whistleblowing policies and any reporting mechanisms that you might have in place. Trade union changes then in here. What we're seeing is the reforms to statutory union recognition. So the statutory recognition scheme for trade unions is going to be simplified. So key changes include removal of the 40% support threshold for recognition ballots and requirement for trade unions to demonstrate majority support for recognition at that initial application stage is also being removed. And the aims of that is to make that process more accessible and efficient. In addition to that, we're going to see the introduction of electronic balloting. And so that's sort of marking that shift from to modernising those sort of voting procedures. So on the 19th of November, we had a consultation paper on a draft code of practice on electronic balloting and workplace balloting. That consultation period ends on the 28th of January, so we await the outcome of that. Then we've got the creation of the Fair Work Agency. So currently the UK has limited state enforcement of employment rights. So what the Act does is it establishes this Fair Work Agency who will have enforcement powers and will police compliance by employers in relation to what we call labour market laws. So that's including your minimum wage, your SSP enforcement, your holiday pay. So what that Fair Work Agency will be able to do is they'll be able to enforce failure to pay certain statutory payments to workers. They will provide legal assistance for employment-related proceedings. They will be able to recover their own enforcement costs from employers who aren't complying with the law. And they'll also be able to enter premises to obtain documents and inspect electronic records. So this is going to be a big change. The Fair Work Agency is going to be established in April, like I say, but it's likely to take some time before those practical arrangements will be fully up and running. And so we don't currently know the timeline for those exact enforcement powers. At the moment, that's a little bit uncertain. So what you just need to be doing is sort of watching this space and monitoring those developments and perhaps preparing for greater scrutiny of your practices in relation to those particular labour market laws. So the payment of your minimum wage, the payment of your statutory sick pay, the payments of your holiday pay. Collective Redundancy Protective Award. So the maximum compensation for a Collective Redundancy Protective Award will double from 90 days gross pay to 180 days gross pay. The changes to collective consultation thresholds, they're coming in October, and I'll touch upon them when we get to that point. This will also apply for failing to consult during a fire and rehire situation. So again, those protective awards are going to increase from 90 to 180 days, and that's going to come in from the 6th of April. Then we've got your statutory sick pay. So this is arguably the most significant change in this tranche of changes in April. So currently, an employee needs to earn £123 per week, which is what we call that lower earnings limit, before they are entitled to sick pay. That limit is completely going and is being removed. So under the changes, employees will either receive 80% of their normal weekly earnings or the current rate of SSP, whatever is the lower. So that current rate at the moment is £118.75. Currently, employees also receive SSP from the 4th day of absence. That's being removed. So employees will have the right to SSP from the very first day of sickness absence. So it's estimated that around 1.3 million employees are going to benefit from these changes. The government's of the view the changes would reduce the amount of people going to work when they're ill, which will reduce the spread of infections, boosting productivity and benefiting employers. But to be quite honest, I think that sort of remains to be seen. So what does that change mean in practice? Thanks, Grace. So it means every employee, no matter how few hours they work, will now qualify for SSP if they earn anything. So a one shift a week minimum wage worker maybe earning £98 will now qualify, where previously they wouldn't have done because they wouldn't have met that lower earnings limit. So you do need to keep this in mind if you have 0-hour contract workers, because they may now be entitled to payment of SSP because of that removal of that lower earnings limit. If you offer enhanced sick pay schemes, which are currently aligned with statutory sick pay, you'll need to reassess them. So, for example, if you have any enhanced sick pay schemes, they need to be updated if they're triggered once SSP starts, because now that trigger is from that first day as opposed to that 4th day of absence. You may also see the financial impact of short-term absences increasing. So, for example, if you have an employee who has regular instances of absence, they're now going to receive pay for all of those days that they're off. So in light of that, you need to be considering updating your sickness absence policies now so you're ready for this implementation. Start monitoring absence patterns and ensure your return to work processes are robust. Train your managers to handle that short-term absence management, capability concerns, and those medical referrals with confidence. And use the opportunity to review how your sick pay policy fits into your overall employee health, well-being and absence management strategy. And of course, update those payroll systems. So those changes from April. Now, if we move on to the changes that are coming into force in October. So looking at those main changes, and these are coming in force from the 1st of October. So firstly, fire and rehire. So from the 1st of October, it is going to become automatically unfair to dismiss an employee for not agreeing to a variation to their contract, save only in circumstances where employers can prove serious financial difficulties affecting them as a going concern. The variation was unavoidable and the process was handled fairly, including with proper consultations. So the existing code of practice on dismissal and re-engagement, which came into force from 2024, so that's the ACAS code of practice, is due to be revised to reflect these changes. That hasn't happened yet. So prior to October, whilst the updated code is awaited, you can look really to be planning ahead. Consider whether you are needing to adjust working hours, job roles, or pay, as you'll need to be looking to achieve those changes by consulting and reaching agreement, as opposed to enforcing those changes and considering dismissal in the event those changes are not accepted. Outsourcing of public sector and TUPE. So the Act introduces powers to avoid a two-tier workforce, with ex-public sector employees and private sector employees being employed on different terms and conditions. We're awaiting regulations on this, and what they may require is public outsourcing contracts to include provisions to ensure that any workers transferring from the public sector should be treated no less favourably than they were when employed in the public sector, and private sector workers working for a supplier will need to be treated no less favourably than the ex-public sector workers who have transferred. So like I say, we're awaiting those detailed regulations. Hopefully that will also provide information as to what that less favourable treatment will look like. They will also produce a code of practice relating to those outsourcing public service contracts as well. And that's obviously, like I say, awaited. Just so you're aware, more generally, there's going to be a call for evidence to examine TUPE and how it's implemented in practice. That was already originally mooted early this year. That's obviously not happened yet. So again, something to just keep an eye out for. Employment tribunal limits. So for decades, it's been the position that most tribunal claims can be brought within 3 months of the act that's been complained of. Under the Employment Rights Act, this is being extended from 3 to 6 months. So this is going to apply to all types of claims. So your discrimination, your unfair dismissal. Curiously, the way in which the Act is drafted, it doesn't currently apply to breach of contract claims. I suggest that's probably an error and an oversight, and that will be corrected. So in preparation for this change, you really need to be considering maybe reviewing and extending your document retention policies. You might need to hold on to those records for at least maybe 9 months after any incident, longer if that litigation seems possible. You might want to look at strengthening your internal grievance and appeal processes. So sort of with more time to raise and resolve issues before those claim deadlines, your early resolution is likely to become more viable. And that probably tallies with the recent changes that we've seen to early conciliation, which doubled from 6 to 12 weeks from the 1st of December last year. Trade union changes. So this is when we're going to see a range of new obligations introduced here designed to strengthen those trade union rights in the workplace. So we're going to see that right of trade union access to workplaces. So currently there is no general right for trade unions to access workplaces for recruitment and organisation of members. Under the Act, trade union officials will now have a wider right to access workplaces. So that's for recruitment, organising and collective bargaining purposes. Now, these changes are subject to one of the consultations that has been published. And what that consultation is specifically asking is what form the union's request for access should take, how it should be submitted, what information it must include. It asks how employees should be required to respond, including time limits for acknowledging or deciding requests, whether they should be able to refuse or negotiate terms. Views are also being sought on what would constitute a reasonable refusal and how disagreements should be resolved. It also asks what type of access should be included. Should it just be physical access? Could it be digital or online access to workers? Whether union reps should be able to distribute information or even hold those sort of meetings during working hours. It's also invited comments on appropriate enforcement mechanisms, levels of sanctions, whether there should be appeals or mediation routes. So that consultation closed on the 18th of December last year. So we are waiting the outcome of that consultation. And you can see how important these consultations are, because it's that detail that is then going to be decided upon going to regulations so that we know how these changes are going to work in practice. What we've also got is the obligation to notify workers of their right to join a trade union. So what the Act does is it expands the list of required particulars that you must give to your employees to include an explicit statement that workers have the right to join a trade union. And again, this element is subject to that consultation. So what that consultation is asking, what should the employer's statement say? Should it be a separate document or part of the written particulars of employment? Should it be paper-based, digital, or both? When and how should the employer deliver the statement? Options include maybe at the start of the employment, if there's been contract changes. Should it be reissued at certain intervals? And again, that consultation closed on the 18th of December, so we're awaiting the outcome of that. What you're also going to see is strength and safeguard for those engaged in union activities, including the prohibition of detriments, for example, disciplinary action or pay cuts related to industrial action. And you're also going to get new rights to paid time off for union representatives with reasonable facilities granted to union reps. And then lastly here, the main big change we've got is on harassment. So probably you should already be aware of that current duty on you as employers to take reasonable steps to prevent sexual harassment in the workplace. That came into force in October 2024. That's going to be extended so that employers are required to take all reasonable steps. So the upshot of that is failing to just take one further step to prevent sexual harassment in the workplace, which the tribunal considers was reasonable for you to take, will leave you open to be in breach of that duty. Now, the government is issuing further regulations, which is going to be useful on what those steps should look like. What isn't useful is they're not coming into force until 2027. So the duty for you to take all reasonable steps is coming into force on the 1st of October. What those steps should look like, the government is publishing in 2027. What we're also going to have is a new obligation on employers to take all reasonable steps to prevent harassment of employment by third parties. So I just want to take the opportunity to expand on that a little more. That's also quite a significant change. So Grace, if you just flip across for me. So currently under the Equality Act, harassment is a form of unlawful discrimination, and an employer is only what we call vicariously liable for the actions of their employees if a colleague harasses another colleague with or without the employer's knowledge. That employer will be vicariously liable for their actions. So as it currently stands, an employer is not currently liable for a third party's actions. So a third party could be a contractor, a client. If you're dealing with education, it can be parents, it could be volunteers, visitors such as nurses to the school, anyone that's sort of not employed by the employer. What the Act does is it imposes direct liability for employers, no matter their size, if they fail to take all reasonable steps to prevent harassment by third parties on their workforce. And again, that's this all reasonable steps, not just reasonable steps. And significantly, that's in relation to all harassment, so not just sexual harassment. So this is related to your other protected characteristics, so age, disability, race, etc. So what I've set out here is some steps that you could look to consider implementing in readiness for this change. We don't currently have any further guidance on that, and we don't have an indication of any further consultations on this either. So we've had to look really to sort of previous case law. So just pulling out some of those main ones, a clear anti-harassment policy. So you want to implement and communicate a robust anti-harassment policy that explicitly covers third-party harassment by others. You want to undertake trainings for employee and managers. So provide training on how to identify, report and handle third-party harassment. Ensure your managers are aware of their responsibility to protect employees from such behaviour. And consider your contractual clauses with third parties. So where possible, include clauses in contracts with third parties that hold them accountable for any harassing behaviour of their employees or clients that they might engage in, and have those regular reviews and risk assessments. That's really important. Just before leaving this sort of area, I just also want to touch upon NDAs, which you might have sort of heard reference to as well. So a separate but related development in the Employment Rights Act, it wasn't included in the original draft of the bill, relates to non-disclosure agreements. So new rules will provide that confidentiality clauses in settlement agreements or other agreements will be void to the extent that they attempt to prevent individuals from discussing allegations of harassment or discrimination. There will be limited circumstances where NDAs can still be used in relation to harassment and discrimination, and they're going to be known as an accepted agreement. So the proposals relating to these NDAs, they came in after that roadmap was published, so we don't yet have any information as to about the implementation date of when that will come in. So that's looking at those changes from the 1st of October 26. And then the last set of changes, thanks Grace, is going to come into force during 2027. At the moment, we don't know the exact dates of those implementation. So what we have is we have bereavement leave. So currently, if an employee loses a child under 18 or suffers a stillbirth after 24 weeks, they can take up to 2 weeks paid leave. What the Act introduces is the right to 1 week of unpaid bereavement leave from day one of employment following the death of a loved one. It also extends parental bereavement leave to include any pregnancy loss before 24 weeks. Now, as I say, that new leave is unpaid. So whilst the provisions for paid leave still apply for parents who lose a child under 18 or they suffer that stillbirth after 24 weeks, those changes introduced by the Act will be for such leave to be unpaid. So you might want to consider potentially enhancing your policies. That's something you can obviously look at, align them with any enhancements that you might currently have in place as well. This is also currently subject to one of the consultations. And what that consultation is asking is which relationships should qualify. Should it be immediate family, extended family, close friends? For pregnancy loss, it asks whether leave should be limited to the person who was pregnant, whether it should include others such as partners, intended parents, those in surrogacy arrangements. It also considers which types of pregnancy loss should qualify. Should it be miscarriage? Should it include ectopic or molar pregnancies, IVF, embryo transfer loss, and medical terminations? The Act, like it says, has this minimum of 1 week's unpaid leave, which is to be taken within 56 days of that loss. And feedback is actually being sought on whether that entitlement should be longer or the time window should be extended, and whether that leave should be taken in one block or flexibly in smaller units. The consultation also asks how much notice should be required and whether any evidence should be provided, albeit it obviously acknowledges that in cases of pregnancy loss requiring proof might be distressing or obviously impractical. And the government also does recognise that many employers already offer compassionate leave in these types of situations, but they're sort of seeking views on these consistent minimum standards and what guidance might help employers. That consultation closed on the 15th of January. So again, we're waiting the details of that. Sexual harassment prevention. So again, as I touched upon, whilst the duty to take those all reasonable steps to prevent sexual harassment will kick in from October, detailed regulations specifying what those steps should include is not coming into force until 2027. So that's going to provide some clear guidance, albeit it's going to be a little bit later than it otherwise should be. Rights for pregnant workers and new mothers. So whilst legal protections against dismissal related to pregnancy and maternity already exist, including we already have enhanced redundancy protection, the Act goes further and it gives the government powers to introduce regulations to enhance protection against other dismissals. So again, this is subject to one of the consultations. And the key issues being explored are what grounds, so conduct, capability, some other substantial reason, should continue to apply to pregnant women and new mothers, or whether a new stricter test should apply. It seeks views on when the enhanced protection should begin. So when an employee informs the employer that they're pregnant. Also, how long after the return to work that protection should last. Should it be 6 months post-return or 18 months from birth? The government is also considering whether protection should extend to other parents, so those taking adoption leave, shared parental leave, and how to support awareness of those rights. Interestingly as well, the consultation also asks how they can support employers through this change and to mitigate unintended consequences, such as employers being reluctant to recruit women of childbearing age, which is obviously really important. Again, that consultation closed on the 15th of January, so we're awaiting a response to that. Changes to collective redundancy. So as we touched upon, so currently employers proposing 20 plus redundancies at one establishment within a period of 90 days must go through that process of collective consultation before making any redundancies. So we've seen that collective consultation protective award increase. What we've got now is a change to the threshold test. So the Act adds a new threshold test. So it requires consultation if there are either 20 plus redundancies at one establishment or if another new threshold test is met. So this is going to be defined in regulations, but it will involve probably counting employees across all sites and work places, potentially based on a percentage or number higher than 20, for example, so the lower of 10%, or 100 employees across the business as a whole. It might look something like that. In the roadmap, the government indicated that it will consult on collective redundancy measures again towards the end of last year, beginning of this year. That's yet to start. Like I say, that consultation is going to cover that new threshold test, plus potentially the question of whether to double the minimum consultation period when an employer is proposing to dismiss 100 or more employees. So again, and that's from 45 to 90 days. So again, we are waiting for the publication of that consultation. Just move on to the next one, Grace, next slide. We're also going to see changes to flexible working rights. So we're going to see stronger rights to flexible working. So currently, employees have a right to request flexible working from day one. Employers can refuse based on one or more of the 8 business reasons, which obviously are set out currently in legislation. The penalty for breaching the statutory flexible working regime is 8 weeks' pay. That's currently capped at 5,600. So under the Act, refusal of a flexible working request must also be reasonable. So although the 8 business reasons remain the same, an employer must state, they must explain what ground they are relying on for that refusal and why that refusal is being considered as reasonable. There's no sort of change to that penalty either. So again, according to the roadmap, consultation on these measures is due to take place. So again, towards the end into this year, it hasn't yet. So again, we await the publication of that consultation. Then we've got the last sort of changes to the trade union industrial action. So what we're going to see here is an introduction of a comprehensive industrial relations framework being introduced. That's going to set out clear rules for union employer collective interactions, possibly including a managed negotiating forum, joint working groups, or sector-level fair pay agreements. And we're also going to see strengthening of prohibitions and penalties against employers maintaining or using lists to blacklist individuals for trade union involvement. And protection of trade union rights is also going to be extended to agency workers. Gender pay gap and menopause. So employers with at least 250 employees will, as well as publishing yearly gender pay gap figures, will also be required to create and publish equality action plans, and they are to address how they intend to reduce their gender pay gap and how they are supporting employees going through menopause. So, for example, that flexible working, whether there's workplace adjustments in place, signposting to health resources, and those plans are to be updated at least annually, and with details, like I say, will be coming out in further regulations. So we await that position as well. I've just mentioned here as well the regulation of umbrella companies. So they are going to be brought within the definition of employment businesses. And that's broadly businesses supplying temporary workers, and they're going to be regulated in the same way. Just go to the next slide, please, Grace. And then we've got here probably arguably the 2 significant changes coming in is those changes to 0 hours and low hour contracts. So what we're going to have is that duty, as you're probably aware, to offer guaranteed hours. So employers will have a duty to offer qualifying workers a contract that reflects the hours regularly worked over a reference period. We also know so far that that's going to be extended to agency workers as well. Consultation on those measures. So, for example, what the length of the reference period will be, the threshold of low hours, conditions on the number and regularity of those hours are awaited. That's expected again early this year is what was said. It's not yet been published. So we will look out for that position. We're also going to introduce under the changes to those 0 hours and low hour contracts, as I'm sure you're aware, the right to reasonable notice of work schedules and proportionate compensation. And so workers are going to gain the right to that reasonable notice of a shift, including the time, day, and how many hours are to be worked. There's also going to be a right to reasonable notice of any change or cancelled shift. And that includes the extension of contractually guaranteed shifts. What's reasonable notice is going to depend on the circumstances. And again, regulations are going to set out what that specific minimum time limit will be. So again, we're awaiting those consultations. They're hopefully going to come out imminently. So it's very much a case of sort of watching this space in relation to that consultation and the details of how these changes are going to work. Then, of course, we have the changes to the unfair dismissal regime. And Grace, if you can just move forward, I've got a separate slide on this. So as you're aware, currently employees need to work 2 years before they have the right to be unfairly dismissed. Labour obviously originally promised day one unfair dismissal rights. We saw that parliamentary ping pong between the government and the House of Lords. And what we have now is that the House of Lords position has been accepted. And what we've got is a qualifying period of 6 months before an employee can make a claim for unfair dismissal. The government has committed to this change coming into effect from the 1st of January 2027. So that means anyone with 6 months service on or after the 1st of January will be able to claim unfair dismissal. That's important because if you're taking on an employee whose employment commences from the 1st of July this year, they're going to benefit from that reduction in the qualifying period if they're still employed as of the 1st of January. As well as the qualifying period, we also receive the removal of the compensation cap. And this was, I think, a little bit unexpected. So when you're looking at compensation for unfair dismissal, what we have is we have a basic award, which is basically based on a statutory redundancy pay. And that's capped very much like your statutory redundancy pay cap is. That's not changing. What you also have is a compensatory award, and that really much effectively is loss of earnings. At the moment, we have a cap on that. So no one can receive an award, a compensatory award, that's higher than 52 weeks gross pay or the statutory cap. So the statutory cap sits at the moment at £118,223. So the 52-week cap and that statutory cap are going. So what that means is the compensatory award for unfair dismissal, which, like I say, is pretty much based on your loss of earnings, is now, or will be, from the 1st of January, uncapped. So it's going to sit like your discrimination claims, your whistleblowing claims, which currently are uncapped as well. There was a suggestion we're going to have an impact assessment that was going to be produced. It's unclear whether there's going to be further consultations on this, maybe unlikely. And it's assumed, or we're just assuming, the changes to the compensation are going to come in on the 1st of January when the qualifying period also comes in as well. So what should you be focusing on? I've put agenda here. Seems a bit obvious, but I think it's a really important point that unfair dismissal needs to be really at the top of your agenda. Its significance needs to be understood now from your senior leadership team. I've put in here your probationary period, your performance management. Use that 6 months period wisely. What you're going to need to be doing is relying on your probationary periods, your early performance reviews, making sure those performance reviews are carried out before that 6 month mark. If you've got someone who's clearly not fit or underperforming early on, it might be safer and simpler to end their employment within that first 6 months than to wait and maybe face a potentially tricky dismissal after 8 months or a year. Clearly, if you can't wait to the end of that 6 months, those performance reviews that you would have been put into place will provide that strong evidence to support any fair dismissal. So what you need to be doing now is getting into the habit, really, of really monitoring during that probationary period. Or if you don't explicitly have a probationary period, it's monitoring that review someone's how they're getting on once they've started with you, because you will really need to be able to use that once these changes come into force. And then, thanks, Grace, if you just move on. Just then talking about some key takeaways. So, and again, the Commercial Services Group research report is again useful to show these sort of key conclusions and takeaways. And what that report shows is that understanding must deepen. So whilst awareness is widespread, detailed comprehension of the changes remains sort of a bit patchy, particularly among middle managers and operational teams. So you really need to, if you haven't already, sort of strengthening your internal communication engagement, keep employees informed of the impending changes, where appropriate, set up forums to discuss the practicalities. It's important for employers to listen and address any concerns raised, have that clear, accessible explanations of rights and responsibilities, and that will then in turn improve that understanding and build that sort of trust. Flowing from that naturally is learning and development. So it's going to be essential to educate your senior leadership, your line managers, the wider workforce, and the new legal parameters. Some of the legislative changes are complex, and it's going to be key to ensure training programs are rolled out effectively. And then I've also put in here, assess and address capability gaps early. So undertake your audits with HR, legal, and your finance functions to identify areas requiring investment, training, or additional capacity, and ensure you've got that coordination across your HR, your finance, and your workforce systems. Cultural change is essential. So by prioritising a culture of mutual respect, that open communication means you're going to be able to have a smoother transition across your workforce. I've also put in here, lead culture from the top. So senior leaders should set expectations that fairness and respect are strategic priorities, supported by practical management training and sort of those accountability measures. And then what that research report also sort of showed is that partnerships are being reassessed. So a more selective, standards-driven approach to agency and recruitment partnerships emerging. So what you might want to look to do is make sure you're aligning your partnerships with values. So review third-party employment and recruitment relationships to ensure your external partners meet the same ethical and operational standards that you want internally. And lastly, I've not included it on the slide, but monitor your impact, share your learning. So establish metrics to sort of track progress on retention, employee satisfaction and compliance, and share good practice across organisations and sectors. And then finally, thanks, Grace, if you just go to the sort of last slide. Not that you need any more information about what's changing, but I think it's just really important as HR professionals for you to just be aware of some other changes that are coming up on the horizon, which are linked to the Employment Rights Act. So what we're seeing is we're going to see the Equality, Race and Disability Bill. So the government's announced that we're going to have a separate Equality, Race and Disability Bill, which will deal with ethnicity and disability pay gap reporting and the extension of equal pay rights to ethnic minority and disabled people. So there was a suggestion that some of these changes would have sat under the Employment Rights Act, but what we've got now is there's going to be a separate bill, a separate act dealing with that. The draft bill's not yet been published, but it is expected sometime this year. So it's just something for you to be aware of. Holiday entitlement and pay records. So again, the Employment Rights Act is going to impose a new obligation on employers to keep records demonstrating compliance with holiday entitlements, so the amount of leave and pay. There's not going to be a set format for the records. They must be kept for 6 years. Failing to comply is going to be a criminal offence, potentially punishable by fine. So again, we're waiting for confirmation of when this new obligation is going to come in. What we've also got is the government's also committed to consultating on employment status. It previously raised the idea of removing the distinction between employees and workers. We'll have to see sort of what emerges. That consultation's on the horizon. And the government's also promised a public consultation this year about employment support for unpaid carers who are balancing work and care responsibilities, as well as a consultation on enhanced rights to flexible working. So thanks, Jane. Thanks, Grace. Just say to the last slide. So that sort of wraps up today's session. Thanks for listening. Hope you found that useful. I appreciate it. Was quite a lot of information, but hopefully you've taken some information away with you. I've put my contact details on the slide. Just to let you know, Legal Connect have also set up an Employment Rights Act implementation and training service. So what that's going to do is provide you with about 14 training modules on various changes under the Act, which will provide that more in-depth detail and considering how you can implement the changes from that sort of practical perspective. And we'll send some more information about that in case you're interested in that in the emails that go around. The QR code also on this slide here is for you to be able to see that full research report that was carried out by Commercial Services Group as well. So thank you, Steve. I don't know if we've got time or whether there's a couple of questions I might be able to have a look at.
Yeah, if people are still online, we've got a little bit of time, Hayley. So thank you very much. I think that really they should have renamed the Act instead of Employment Rights Act, it's a Trade Union Wish List Act. But there you go.
Yes, yeah, I agree with that too.
So a couple of questions. One of them about SSP was answered by one of the attendees. So thank you very much for the answer, Jill. Had a question from Sally about multi-site as a multi-site employer. They currently submit their umbrella HR1 for redundancy purposes for across one organisation. They just wanted to check, is it okay if the Employment Rights Act widens the HR1 trigger? Does it need to be multiple HR1s, or can it still be just one notification rather than one per location?
To be honest, Steve, I don't know the answer to that, so I'd have to have a look at that sort of specifics.
Okay.
What the Employment Rights Act, because what it originally done, the Employment Rights Act was wanted to remove that sort of one establishment. So when you were making 20 or plus individuals redundant, they wanted to include sort of all sites. So, for example, if we had our academy trust, you'd have to include all those schools in that 20. They've stepped back from that. We have got the 20 plus at one establishment, but because they've stepped back, that's when they've introduced that sort of new threshold, which we're awaiting those regulations on. So it might be that detail comes up further down the line, but I'm happy to have a look at that and just check that position. I'm not sure where that's come from, but you can obviously let me know and I can have a look at that and email out and just see if there is any more information on that we know about at the moment.
Yeah, that's fine. And I think you answered the one during your presentation. There was another one just about probation. And I think you covered that because they were just asking, look, if the probation period of 6 months is extended, uh, does it impact on the unfair dismissal, the termination if the employment? And you covered that in fact that actually be aware that if you go over the 6 months, then you're going to fall into the unfair dismissal rights bracket.
Yeah, exactly that. So you need to start really looking at if you've already, I know sort of in the education sector, we don't, apart from youth support staff, we don't sort of freely see probationary periods as much. But one, you need to be looking to introduce them if you haven't already got them in place. Secondly, if you have got them in place, you need to be looking at how long they are, because that's exactly that. There's no point sort of having an extension, which is then going to take you over that 6 months. So it might be that you look at maybe just reducing that initial probationary period to 3 months with then a potential extension of 1 month if there's any issues, so that you're still within that 6 month period. Because you're going to have to use them to your advantage, because that's all you've sort of got at that time, now with those restrictions coming in. And like I say, don't feel, I mean, there's going to be cases where you don't feel you can dismiss within 6 months, but as long as you're implementing those reviews so that you've got that evidence, so that then if you do dismiss and they can bring a claim, you can show, well, there were issues here, and here, and we address those with those individuals. So actually, it's fair for us to have now dismissed.
Yeah. Okay, thank you. So as Hayley mentioned, she provided her contact details in the slides. The slides will be available via the PPMA website at some future point, probably at some point just next week, as well as this webinar if people want to go through it again. So that's through the ppma.org.uk website. So thank you very much for your attendance today. Thank you, Hayley.
Thanks.